My name's Coe Baxter. I'm an attorney at Prince Glover and Hayes, and I'm very happy to be here to speak to you on a subject matter that I'm passionate about, a law firm is passionate about, Gartlan's passionate about, and that's why we wanted to put on this free CLE, to grab some tips, some strategy on which to face Goliath. I think everybody is familiar with the story of David versus Goliath. Goliath being the giant, coming down, insulting the Israelites. David, a young teenager, after 40 days, comes down to the battlefield after his father tells him to go check on his brothers. And here's Goliath, insulting his people. He's not scared. He stands up to Goliath because he doesn't see Goliath as this big giant with armor and swords that has years and years of training. He sees it from a different perspective. He sees his weaknesses, and through those weaknesses, he can defeat Goliath. And that's exactly what he did. With a well-placed shot with a slingshot, went through a hole in Goliath's armor, knocked him unconscious, and then slayed him with his own sword. Now, this is a metaphor that I'm sure that you've all heard at some point in time in a life experience, overcoming obstacles, but I think it's most appropriate in the legal context. Because where can you have an individual plaintiff like David go against big business, big insurance like Goliath? Only in a courtroom. And that's not to say it's not fair, because it's not. Goliath has more resources, more money, more lawyers. I have a case right now against John Deere. 7 lawyers. 7. That's more lawyers than we have in our entire firm. So, but with some strategy and some tips and knowing do the right things, you can defeat that. It doesn't matter how much resources they have. It doesn't matter how many lawyers they have. Just approach it in a different perspective. Now, I'm going to touch on a few things. It's kind of an introduction, and then Matt, my colleague, will come speak, and then Aaron, but you're in for a really good treat because I get the opportunity to work with Matt every day. He's my mentor, and Aaron works with Matt a lot, so through Matt, I work with Aaron, and I believe they're two of the best trial lawyers in the state. Excuse me. So let's get started. How do insurance companies work to maximize profits? Now, if I took a poll in here, I can guarantee you probably 90% of you have heard this word: jackpot justice. Something for nothing, too many lawsuits, frivolous lawsuits. But have you ever seen any data? Have you seen any facts behind that? From a credible source, not a think tank that's funded by the insurance companies, just data from the court system. Well, their propaganda is not accurate. This is reality. This is taken from the Alabama Unified Judicial System. It's a report going out from the Office of the Judicial Administrative Offices, and this shows you last 5-year average, the filings. See, torts, that includes a lot. And these are the type of subject matters which the insurance companies jam down people's throat to say, these are just frivolous lawsuits. There's just too many of them. 4%. 4% of the filings in a 5-year average were torts. They don't want to show you this because this refutes everything that they spew. Again, same source. In 2010, 2011, 2009, 2010, civil filings. 12 more than 2009 that were filed in 2010. You come down here, civil, 5,000 less lawsuits were filed in Alabama. And it's for good reason. We're up against a lot with partisan judicial elections, the Supreme Court. It's hard to hold on to verdicts. But you hear about frivolous lawsuits so much. Think about the safeguards that are in place to prevent frivolous lawsuits. We take these cases on contingency fee. And in some cases, we have $60,000, $100,000 wrapped up in expenses in a case. Do you think we're going to file a frivolous lawsuit with $100,000 on the line? No. And I wouldn't expect you to either. But even filing a lawsuit in the beginning is expensive. You want to lose $300 just to file a lawsuit? But not only that, you have other safeguards. Motion to dismiss. Motion for summary judgment. You get a verdict, they can remit it. Don't remit it, go to the appellate courts. And we all know what happens if you go to the appellate courts. This is a 10-year number of cases. And you'll see this is how long it takes, anywhere between 4 to 6 years for a civil case in Alabama. On the civil cases, got a verdict, 26 kept them. 26% of the verdicts rendered in Alabama, only 26% held their verdict. So there's a lot of safeguards in place to refute against the frivolous lawsuits. Too many lawsuits. Jackpot justice. Now, another way the insurance company works to maximize profits is minimizing the extent of the injury. And I'm going to be talking about pre-suit and post-suit, because a lot of times you may not have to file a lawsuit. And I'm going to be talking about insurance companies. I know I did a pretty good job of bad-mouthing them, but they're not all evil. Not all adjusters are evil. I'm going to show you a trucking case. All truckers, all trucking companies, and any other potential defendants, they're not all bad. I've had many cases against trucking companies in which the driver and the company did the right thing and followed the law. But minimizing the extent of the injury, this is how they do it. Gaps in treatment. I don't know if you've ever heard that word before, but the insurance company adjuster, this is how they say it. If your client is hurt, they go to the doctor every day. If they don't go every day, they're not hurt. And if you have a gap, let's say they go to the doctor, and then a month down the road they go to the doctor again, well, that's a gap. And they conclude, obviously, that, well, if the client's not going to the hospital, then obviously they're not hurt. But, that's not accurate. Life gets in the way. Nobody likes to go to the doctor. It takes a long time. People have jobs. It's a hard time to get there because they were just involved in a wreck and may not even have a car to get there. But this is a good way that I found out to kind of rebut against this. This is a letter that I send out to treating physicians. This is pre-suit. And it basically asks them to link up the wreck if they can, prognosis, future treatment, medications, what type of limitations, range of motion, stuff like that. Normally, I get a doctor respond fairly quickly. Some charge, some don't. But usually these letters, they're positive. And even if it's $500, it's so worth it. Because obviously the medical records, the insurance company is just putting in codes from the medical records. They don't get a neutral third party like this when I send the letter back to them. So it serves two purposes. One, pre-suit, I send this and hopefully we can get the claim resolved. If not, when I file a lawsuit, 2 years later down the road when I get to deposing this doctor, he gets handed this if he's wavering. And I don't think he's going to refute something he wrote 2 years ago when I enclosed the medical records and nothing has changed. So I think this is a pretty good idea to work in your practice. Like I said, some doctors don't charge, and if they do, don't charge that much. And I usually put in here something about, you won't be needed at a later date for a deposition. I think most doctors like that. So they're usually pretty good about responding to these. Now, the one thing that I was told years ago from my senior partner and Matt and Josh Hayes was that this is what we do. We prepare every single case as it's going to trial, no matter what, no exceptions. Even if we think we're going to be able to resolve it in the claims process, we always focus on trial. You know why? Because if you get delayed, if you think this is going to get resolved pre-suit, what if it doesn't? Then think when you file your lawsuit, you say, oh, it's going to get resolved. We're going to have mediation. It'll get resolved. Then the trial date comes. And the defense attorney is not going to let you out of it, and he doesn't want to join in you for a motion to continue so you to get something. Take some more doctor's depositions, etc. So focus like you're always going to trial. It starts from the initial client meeting. Get all the information there, and then you get started. You start investigating. These are some things that are automatic that we send out, and these are pre-suit stuff. This is something you can do very cheaply. Photographs of the scene. Obviously, when a car wreck happens, after a month or two, rain comes, they wash away the evidence, they wash away the skid marks. Go out there and take the photographs. They're going to be essential. If you resolve the claim or you resolve the claim in the claims process, well, good. You spent $5 on photographs. If not, they're going to be powerful at trial. This is Freedom of Information Act documents. We send these out on trucking cases. And again, very cheap. Sometimes they're free. And this gives you a 3-year period on a trucking company. And most of the time, truck drivers drive the same tractor. And it doesn't give you the name. However, it does give you the license plate. And when you get to deposition, and this is work product, by the way, so when you get to deposition, you ask him, do you drive the same tractor every day? Yes. Do you drive it, if you drive it the last 6 months? Yes. Drive it the last year? Yes. And you go back to them, and you got him. Because if he's got any violations, it will show up in those FOIA documents, and all you have to do is match the license plate to the violation. Same thing with OSHA regulations. Send a request. You can send a request to Alabama. Aliquot search. I do these every time before I send out a demand to the insurance company if I'm trying to resolve a case in the claims process. Can't tell you how many times this has upped the value of the case just by doing a quick search on Aliquot. You may find that you have a fantastic negligent entrustment case. But if you didn't have this information, the value of your case goes down. And that's what the insurance company wants you. They know that the driver has multiple violations. They just hope you don't know that. That way you don't bring it up. Same thing with this. This is $5.75. Check to the Alabama Department of Transportation. You get it's a little bit more in detail because sometimes on Aliquot and their MVR, they're different. So they may have more violations. So right there, you may have spent $12 on something that will significantly up the value of your case. Facebook. Now, you hear, at least I do, I hear all the time defense lawyers, don't destroy the Facebook with your client. You know, and I always tell them, lock the Facebook. Don't show it. You know, don't talk about the case. But of course, Facebook is, I guess, essential to young people's lives, and some older. So when they use it against us, why not use it against them? In fact, I have a trucking case right now in which the truck driver has a Facebook, and he talked a lot about the wreck. And it was really good. And of course, I printed them all out, and he's talking about, you know, getting drunk the night before, stuff like that. Now, while not relevant, it's still good information to have when you're taking his deposition. This is a letter that we send out automatically when a trucking case comes to us. This is a protect and preserve letter. Now, obviously, we ask for a lot of stuff. But by federal law, the Code of Federal Regulations, a truck company does not have to keep daily driver's logs only for 6 months. So if you think that, hey, I don't need to file this case, I'm going to try to get it resolved in the claims process, well, hopefully you do it in 6 months. Because if not, those driver's logs are gone. Maintenance on a vehicle, 1 year, gone. So a lot of times we send this, and most of the time we file suit in the trucking cases, so we get to preserve that evidence because they'll destroy it anyways. But you'll see that inspection reports, qualification files, annual inspections, ECM, which is very important. I know Matt's going to talk more about that. And driver's manuals, Qualcomm, Q-Tracks. I mean, all this stuff is vital evidence, good or bad. I mean, what if the truck driver did everything right? Well, then, you know, VORAD system, your ECM data, they're all going to show that he did the right thing, and that's fine too. But a lot of times, it's important evidence to show that they didn't do the right thing, and it's not there. I will tell you that something's important on the protect and preserve letters, that you do have to put something at the very end that says that we will pay for the reasonable cost of protecting the information, or you won't be able to use that spoliation of evidence charge at trial. So make sure you put that in there. Another thing about preparation. This is a case, and I'm going to go more in detail after this, but this is an affidavit from a trooper that I got. I got this right after I filed the case because I saw that it was assigned to a certain defense attorney firm, and every time it's a liability question. They make it a liability question to drive down the damages, to make me think, well, May lose at trial. It's a liability question, so maybe I won't take as much. Well, to defeat that, I go straight to the trooper and get an affidavit immediately. And there, he tells me everything I need to know. Liability question's gone. Can't use that anymore. I guess they can, but I don't know if I'm sure a jury's going to believe a trooper. And this is the case I'm talking about. It's in Tuscaloosa County, one of mine. It's a trucking case. My lady and 3 of her children on a Saturday were driving in Tuscaloosa. She had just picked up her kids from a school function on the Saturday morning, pulled out, and a truck driver ran the red light and hit them. Pretty bad injuries. No ECM data. They erased that. Still got the trooper's affidavit, so that's good. Still got the spoliation. Well, they contacted me and said, hey, let's mediate this case. Let's mediate before you and I would spend a bunch of money and expenses. And I told them I couldn't do that. There's a reason for that. Because you don't know the value of your case until you get into discovery, especially in a trucking case. If I would have agreed to it, I would have missed a lot of information. But I told him, I said, listen, we got to at least do some very preliminary discovery, so I need to know the value of the case. I got to be able to assess it. When I asked in my interrogatory traffic offenses, driver said, I got some speeding tickets, got some overweight tickets, don't know when, don't know where. So I think I got a citation for a medical card. Well, of course, we subpoena a lot of different places in trucking cases. And I subpoenaed the Alabama Department of Public Safety's abstract, which this is going to contain a lot more information than your MVR request. Okay, and I'm picking on this guy a little bit because it's probably the worst driving record I've ever seen. Actually, it is. You'll see suspended, suspended, disqualified for driving a commercial motor vehicle. He was actually disqualified to drive the commercial motor vehicle during this wreck, and he was over hours. Running red lights, speeding, the list just goes on and on and on and on, and there's your accidents too. Now, had I agreed to mediate this case early, how much do you think the difference in the value of the case was had I not had this information, and it is when I did go to mediation and I did have this information? It was powerful. They couldn't just argue injuries. How much is your client's injuries worth? Well, let's talk about that, but let's also talk about punitive damages. Because if there's any case in which wanton entrustment, negligent hiring, training, supervision goes to the jury, I would expect this one too. This is the safety manager for the trucking company, and he's a good guy. I liked him. He's a very nice guy. It's sad, though, that they try to put profits over safety. And when I asked him a specific question of why you retained this driver, this was his answer. Talking about looking at this record and having Mr. Pugh driving for you, is this a good record to be driving?
No.
Why was he retained and not terminated?
Like I said, for what type job we do, I felt Darryl was doing a good job out here with us, the type work we do.
You keep saying the type work you do. What do you mean by that?
He was a good wood hog, a good truck driver for taking care of his equipment, keeps his, all his documents up to date, does good paperwork.
Okay. They retained him because he took good care of his equipment and basically did a good job at his job. And that's true. That's good. But when you have those types of violation, you're putting the public at risk. How would you like to know that one of your daughters, one of your sons, your wife, your spouse, is driving on the road with a guy whose license has been suspended 12 times? Not in a vehicle, but in an 80,000-pound bullet. This is the kind of stuff that you have to show the insurance companies, show that we're not playing around. We're trying to protect the public at large, the community. Because this actually was a South Alabama case. He was driving through Dothan. He was driving through here. So, and that's why I wanted to show you this. I mean, you never know that this guy was driving through here with all that bad record, and he had a suspended license. Now, this is the third-party trucking discovery that we send out, again, automatically. Just want to show you this. This is High Right Inc. I know some of y'all probably heard about this. It's a background check. It's kind of a third-party administrator for trucking companies to send in information about truck drivers, and you get their MVRs, you get what the previous employer said for their request, a lot of information. You do have to file a motion to file an out-of-state subpoena because, and you have to get an order because it is under the Fair Credit Reporting Act, but they're really good about giving it to you once you give them the order. Alabama Public Service Commission, that gives you a lot of information on the trucking company and any violations that occurred with them directly. Same thing with the driver. We just saw that. And, of course, do that for your out-of-state drivers. They may have held a CDL or even just an individual driver in Georgia or Mississippi. You know, get those. Subpoena those as well. Previous employment records, you know, obviously in trucking cases, this is really, really important because there's going to be inconsistencies. If a truck driver or any individual has been employed and he wants to lie on his application, he's been working for maybe 6 different companies, you're going to find out a gold mine of information when you follow that trail. Cell phone records. Now, this is going to be probably the most important come August because now the text message law comes into effect. So when you get these cell phone records, ask for text messages. A lot of times they say these are not relevant. They might have attorney-client privilege information on them. Well, now they are relevant because it's against the law. And now you got your negligence per se right there. So if you get your cell phone records and you see a text message at the time of the wreck, you got it right there. Wreck reports. This is a problem. A lot of times clients come into our office and they bring in their wreck report or we get their wreck report and it shows that they're at fault. And they say, you know, I wasn't at fault, I promise. And because of that wreck report, the insurance company denies claims. Well, it's coming from a police officer, a trooper, a sheriff, who's not worried about who's at fault. He's worried about getting people to the hospital. He's worried about taking care of people, you know, making sure the scene is safe for other travelers on the road. He doesn't care who's at fault. And again, the accident report's not even admissible in court. So I try to take the accident reports with a grain of salt. I try to do my investigation first to determine really who was at fault. And this is an accident that occurred in Tuscaloosa, northern Tuscaloosa County. Unfortunately, my client was killed in this accident, and the passenger was severely injured. This happened when she was coming out of a driveway, and a truck driver hit her. Now, you think, like I thought, pulled out in front of the truck driver. Okay, no case. Truck driver wouldn't do anything wrong, couldn't avoid her, etc., contrib. That's probably the insurance adjuster's favorite word. But after discovering some more facts and looking at it from a different angle, just like David did Goliath, this is the first accident report. Shows 55-mile-an-hour speed limit, truck driver going 55, nothing wrong with that. Well, we went out there and took pictures of the scene. We found out that it's actually a construction zone. So, taking his 55 miles an hour, if that was correct, he's 10 miles an hour over the speed limit. So we want to dig some more. Well, we got his ECM from the electronic control module. 79.5. Now, I understand the contrib argument. I mean, yes, it's an argument to be made in this case. That's excessive speeding in a commercial motor vehicle, and that's why you get an expert. The expert determined, based on the most conservative thing, not even the ECM data, because unfortunately the ECM data, when you pull that report, there's a clock on it. You get a stamp, and you use that stamp as far as looking at times and looking at the time on the ECM data, and we don't have that. I don't know what they did with that, of course, but the most conservative on a drag scale had him at 62. Why? Because he threw my client's van 426 feet. And if he would have applied his brakes after he had 3-second perception time to react. And this is based off a witness, he could have avoided this wreck. My client would have been pulling into the driveway, or I'm sorry, pulling out of the driveway and onto the road, still be here today. Experts are very important. Now, I know a lot of times that you get the biases, you're paying these experts a ton of money to be on your side, but they do too. And experts are powerful in cases like this. When you have a case that's very shaky. We were close to turning this down, this case. And thankfully we didn't. We did our research. We worked hard. And I just want to show you this. This is kind of an accident reconstructionist diagram or animation of the accident scene. Didn't use it, but still, animations, we do the jury questionnaires after a jury trial, and we say, what did you like? What did you not like? Did you not like the lawyer? Did you not like the exhibits? What was powerful to you, what was not? And animations always come back because it takes them to the scene. And it's supposed to play. Just to show you. And it takes the jurors to the scene, and they get a better idea. It's not just people talking about it. They're actually seeing it. That's basically everything that I have for this. I just want y'all to be aware of some of the issues as far as to get an accident report that says the potential client that's in your office is at fault. Investigate a little bit more. The police officer may be wrong. Like I said, he's worried about, getting people to the hospital, doing his job, not worried about litigation that's coming after this and who's at fault. Does anybody have any questions? All right. Thank you very much.